Kudos to Matiangi. I mean, to come out and talk like that, you must have some authority in you to do that kind of running the riot act on a parliamentary select committee. And I mean, where
he
he
almost
gets
lecturing them.
Yes, where he gets the power to do that, only God knows, because it's beyond my understanding to have somebody who is summoned by the parliamentary select committee on something that is likely to catch up with him, because what we are seeing at the moment is a culture of defying orders. Next, we'll see people defying orders to even appear in front of the parliamentary select committees. Yet, the government structure is very clear that there is the executive, there is the judiciary, and the legislature. So we have a trend that is now emerging, where either the executive is delaying in obeying court orders, is obeying court orders half-heartedly, or simply ignoring court orders, which is a dangerous precedent to set. And given the fact that a lot has been said about what Cabinet Secretary Matiangi has done for this country, he had enough facts. Even in his addressing of the Parliamentary Select Committee, you'd actually see sense in everything that he was saying. And if only he had the courtesy, first of all, to do it in a very diligent, dignified manner and respect the authority that the Select Committee is. If only they had respected the court orders from the word go, I think we'd be talking about a cabinet secretary who is doing a great job. But one thing that you may want to remind individuals in authority who are disobeying court orders, who are getting away with the things that they're doing, is the fact that accountability is perpetual. It will always catch up with you. But power is infinite. No one is in power for the rest of his life. We are seeing it all over the world. We are seeing what is happening in South Africa to President Jacob Zuma. We are seeing what is happening in South Korea. We are seeing a number of former powerful people, heads of states. So it is incumbent upon Matiangi and probably the other cabinet secretaries to entrench a culture where the separation of power is very clear, a culture where each arm of the government respects the other arms of the government, a culture where the rule of law is supreme. Because you cannot, in one instance, disobey a court order and in another instance expect the same court to listen to you. If there is a clique, and he puts it very clearly, if there is a clique of people in the judiciary who are in cahoot with the opposition, I think the rule of justice is very clear, that if you don't agree with a court order, the natural course is to appeal. And I think if we had a system where the executive was appealing these things and putting its case soundly in order like Matiangi did, we'd be talking about a country where the different arms of government work together. But it is. I can say that it is very unfortunate that a cabinet secretary that we've celebrated this far is probably, on the verge of undoing everything good that he has done.
All right. Utinda?
Yes,
Matiangi is out of order in this.
As a constitutionalist, I got very concerned because, you see, the same powers, actually, the Constitution uses the language that the county assemblies and parliament have got same powers as the High Court when it comes to summoning. So there's a reason why they use reference to the High Court. So the issue of you choosing who to appear before and who not to appear before, yet the Constitution is very clear, is quite something. Let me say this as a constitutionalist, that anything that undermines our institutions is something that should make all of us get concerned. Why am I saying this? Because we've had a process whereby we are trying to bring back confidence in our institutions. And I want to give you an example in 2007 when we went for the post-election violence. If you can remember very well during that electoral dispute, it was very clear from one of the parties involved in that dispute that they were not going to explore the avenue of going to court because they did not have confidence in the courts. And it was bought by the public because clearly the public also shared in that concern that these are not courts that you can take your case and expect justice. Then we went for a referendum, created new institutions, and in a new way that brought back some confidence. And you remember in 2013, we had the same dispute But this time, no one had the moral authority to tell us that they're not going to go back to court, because even the public were not ready to buy that, having gone through a process where they were rebuilding confidence in our institutions, including the judiciary. And you remember the judiciary ruled, and even those who were not happy had to respect their decision. Come to 2017, again the same happened. That simply says that we have come a long way in building confidence in these institutions. So nobody is above the law, and nobody should feel like they are more important or they have a case that justifies them rubbishing or undermining our institutions, because we have to know that we are building a nation, we are building a state, and one of the key pillars that make people have confidence is our institutions. And I have to mention that the president and the deputy led the way in regard to that. I had him mention about embarrassment. If his boss, the commander-in-chief, was summoned by the Hague and appeared before the Hague when he was still the president, same to the deputy president, who then is this officer who feels that it is embarrassing for them to subject themselves to the rule of law? I think that is the bigger picture, and we should have borrowed from our leaders, because if there is someone who probably at the basis to say, forget about those, I'm the commander-in-chief, the Kenyans have already expressed their confidence in me by voting for me, it was the president and the deputy, but they didn't do that. So even the issues that Matiangi was raising, I would have been much happy if those issues had also been taken to courts, so that you also raise them there. Then how then do you decide you rubbish that? Then you now decide, okay, this one is probably more convenient for me to. I don't think we should have that privilege of choosing which arm of the government we should subject ourselves to and which one we shouldn't.
And I believe the Constitution is very clear. A court order is a court order. You obey it, you seek redress
Actually,
later.
the Constitution says that all sovereign power belongs to the people, and that it shall only be exercised in accordance with that Constitution. Right. So when you're giving us very many stories that are almost very convincing to those who probably don't understand how the structure of the law works, yet the principles that are governing us, you are in violation. I don't think we should give people that privilege. And as convincing as you think your case is, you should just take it to the right arm of government that is dealing with that particular matter.
All right, let me pick it up from where Mutinda has left it. There's a school of thought that says, because Mutinda says if the commander-in-chief himself appeared at the Hague, he also respected that Supreme Court ruling, why then are his officers not obeying the courts? There's a school of thought that seems to think that it is just Matiangi just doing what he wants, maybe because of the power that he now wields. Others think that this is coming from above. Maybe they felt with the Supreme Court ruling, they were really ceding a lot of power to that arm of government. What gives?
Well, your question is very pregnant, and it should be answered in three parts. The President of the Republic of Kenya has subjected himself to the rule of law, to the Supreme Court on 2 occasions.
Yes.
And he has respected that. The last time he was a bit disappointed, he expressed his disappointment in public, but he still subjected himself to the rule of law. And what Mutinda Kavemba has mentioned about going to ICC. So there are no two ways about it. Willy Mutunga indicated, and everybody knows it, even if you haven't read any law, but you just Google the Kenyan Constitution, that a court order is not a suggestion and it's not a proposal. That nobody in Kenya has got the option to pick and choose what court order you are going to respect and which one you are going to discard to the dustbin. So any government officer in Kenya today must respect a court order. If you are unhappy with the court order, and Mutunga indicated that even if it's a stupid court order, even if it's foolish, there's an appellate process. Go to the next court and make your case known. Like, for instance, when Dr. Matiangi was at the National Assembly, and I'm not going to use those words that he gave the members of the National Assembly a lecture, but he presented a very overwhelming case. And when you speak to a number of lawyers, in fact, they said Dr. Matiangi has got a case. That for Matiangi, before 2010, he denounced his Kenyan citizenship and he was given a Canadian passport. Inherently, his ID is not valid. And on the other hand, after 2010, we are told again by lawyers that you cannot lose your citizenship by birth. Nobody has got the powers to take it away. Now you've got a dispute. Then the only sober way is to go before a court of law to give instructions, to give directions, because that's their responsibility. And in my view, what the National Assembly ought to do, now that you've got this handshake, others call it a declaration, is to amend the Contempt of Court Act, because the penalties are laughable. You disobey court orders, then what happens? You are given 6 months, or you are given 200,000. Now, 200,000 for these public officers is pocket change. This is money they spend in an evening on a single malt whiskey and pepper steak. It will not have any impact. Maybe what they need to do is have that penalty go to 6 years in civil jail, and then maybe 10 million fine, so that the punishment is so punitive. But the idea that Dr. Matiangi and other people can disobey court orders and go away without a fight, the back has to stop with the appointing authority, because the appointing authority is the president. So if there's anybody who works under you who disobeys court orders, it means that there is a tactic approval for it. Because if the president was disappointed that his officers are disobeying court orders, then he would have probably fired them. In my view, because the president has not said anything, or maybe there's been internal communications that we are not privy to, but in the absence of formal communications in the public space, then there's a very high probability that the president is happy with what is happening.
Mark?
Let us assume that you're a government, okay? And in your imagination, or in reality, you have a judiciary that is hostile to you. You have judges who you perceive issue orders that undermine the executive, and you imagine also that you are curtailed in your capacity to implement certain projects because of certain court orders that have suspended projects beyond the procurement period. Let's assume that is true. Then the question must be asked, what is the greater responsibility? Is the greater responsibility to the public and maintaining the rule of law, or settling a score between yourself and the executive and the judiciary at the expense of what is the tradition and culture around courts? Now, that is where there is a split. Matiangi, indeed, his grievances are valid. We all have the capacity as Kenyans to disagree with any ruling. We have the capacity to be taken to court for a traffic offense and say, Judge, I disagree, but do I still pay the fine? Yes, I do. And therefore, what is needed here is whoever is advising Matiangi needs to separate the issues. Because the reality of the matter is this, that if I'm going to decide for myself that a court order is nonsensical, then what stops every other Kenyan from deciding the same from where they sit? They say that the law is on us, and they say that for a reason. They also say that justice must be blind, and they say that for a reason. Meaning that once the judge rules, you must accept it as the new reality. In the newspaper, when you are arrested, it is alleged that you are a criminal.
Right.
Once you are judged, it is confirmed you are a criminal until you finish the appeal process. So what this country must do, it must return to sobriety. Is there an issue between the executive and judiciary? Yes, there is. But should they determine these issues in the way they are? No. There needs to be a conversation,
right.
But court orders, in my view, must be respected. At the same time, the issues that Matiangi has should be addressed in the proper manner, right, and not by abandoning the court process.
All right, let's hear what the courts have been saying. And the courts have been saying that court orders are indeed orders and not suggestions. Here is Justice George Odunga on the same.
Apart from contempt of court proceedings, this court must ensure that its orders are complied with. The matter before me is no longer a dispute between the parties, but has now reached the level where judicial powers are on trial, and the dignity of this court is being questioned. This court cannot just fold its arms while the respondents continue to cut work on its orders. In the premises, I make the following orders. First, second, and third respondents have by their conduct been in contemptuous of the orders of this court, and they are convicted accordingly. The said respondents will appear before this court tomorrow at 10 a.m. for sentencing and further orders. In default of their appearance, this court will proceed to mete out appropriate sentences, their absence notwithstanding.
As High Court Justice George Odunga, we also caught up with the Chief Justice, David Maraga, to seek his opinion on the same. And here's what he had to say. All right, we did talk to the CJ. Of course, he did reiterate what the judges have been saying, that court orders are orders indeed, and not suggestions. To wind up on this, Hezbon, is the back and forth between the judiciary and the executive now, does it bring a danger of that supremacy battle coming in the way of, the merits then of those issues being discussed and whose rulings are being issued in courts?
It does. To a great extent, it does make the public have this sense that in a court of law, it is no longer about the merits and the demerits in the arguments and the evidence that is adduced in court. It's a question of how powerful individuals are, which is very unfortunate. And probably what we may want to ask ourselves is there a situation where we can have a justice system that has this veil of ignorance, that when they're meting the justice to either parties that are litigating, they assume that they have a veil that sees all these people as the same. And I think our justice system, based on what has been going on in the recent past and what Dr. Matiangi is saying, is now put in a situation where even everyone is looking at it in terms of, does it really look at anyone who is presented before a court of law as a Kenyan without due respect to the other positions that they occupy in the society. So I think the onus is on the judiciary, the executive, and parliament to try and redeem that, so much so that we return back to the judiciary that was reformed, the one that everyone believed in. And it is not a very interesting place to find ourselves, where we have again to entrench the belief in the judiciary, given what is going on. And maybe if I refer back to what happened some 3 weeks ago, I think 3 weeks ago, we had the ICT, Cabinet Secretary, Joe Musheru, appear before a Parliamentary Select Committee. Irrespective of what he had done and what the responsibility in his ministry were then, the way he responded to the Select Committee, which has the equivalent power of a High Court, probably should inform, subsequent appearances to either courts with a lot of respect, because he did that with a lot of respect, and he addressed MPs with the due respect that they deserve as a group that has the powers of a High Court.
All right. Mutinda, are we seeing, somebody did suggest that in the past, we had ministers and assistant ministers who were also members of parliament, and now we have cabinet secretaries who are just that. Yes. Does that contribute to that power struggle between, especially the parliamentary committees and the cabinet secretaries?
At the end of the day, the constitutional framework is very clear, and everybody has got their own powers. And, there is the duty of being proactive and asserting yourself when it comes to the powers that the Constitution has given you. So at the end of the day, I think it is incumbent on all these arms and institutions of government to flex their powers. And, let's even take this issue of the judiciary, the perceived differences between the judiciary and the executive, because as from where I stand, I think they are perceived. You need to understand that one of the problems we had that led to what I was telling you about the post-election violence was that previously, prior to 2007 or prior to 2010, it was almost a foregone conclusion that whenever there is a dispute pitting the government against someone else, the government would have its way. If you remember, during the vetting of judges, there are actually judges who went home because of openly favoring the government, even when the government was on the wrong. And these are the things that we need to, actually, as a progressive Kenyan, I think it is something that is almost pleasant, that now we are having a judiciary that is flexing itself to a point that the executive is crying a fall. In terms of whether we are strengthening our institutions or not,
right.
I think, in short, the judiciary is asserting itself. So if Parliament gives people a leeway to trample on their mandate, then it is going to be upon them. It is important for all institutions to seize the power given to them by the people through the Constitution, so that nobody is playing around with the checks and balances that we've put in place. The control of budget has been doing that. The Auditor General has been doing that under very difficult circumstances. But then what would have been the basis or the justification for us going through all these reforms if we end up having individuals who don't have the backbone to stand their ground when especially the Constitution is on their side? That is the kind of thing we need to see, so that, like I told you, I'm a proponent of strong institutions.
All right. Yes. But just allow me to make a point.
Very quickly.
That the judiciary should not be dancing to the music as played by the executive. No. They should be dancing to the music as played by the Constitution.
Exactly.
And it must not be lost on people that it's not as if the judges sit in their chambers and then from the blues they come up with orders. It's parties who make presentations.
Right.
Now, if as a government, if as an executive, you've been invited to make a presentation and you ignore Justice Odunga's orders, you go doing your own activities, what do you expect Justice Odunga to do? He will proceed and make rulings or judgments as issued. And in my view, we should have a very strong judiciary, a very strong executive, and a very strong legislature so that we make progress. And the judiciary has been a stabilizing factor in countries like Pakistan. And the way Kavemba has indicated, we should all break into a dance and song that we've got a number of judges who can stand up to cabinet secretaries.
All right. Very important conversation, debate that continues. Matiangi, Kihalangwa, and Boynet still on the spot. Very many people saying that they should indeed they should be seen as people not fit to hold office because they have not protected the Constitution. That's why we leave it. Let me just take a look at some of your views very quickly on some of the things we've talked about. Blamwell Njuru says, tribal politics has always reared its ugly head since independence when Kenyatta and Odinga led KANU. Moi and Ngala had KADU, the Baluya torn between parties, Ngei leading the Akamba People's Party. Same pattern is emerging. On 2K says, was it really a handshake or a hand check? And one here, Abdallah Kasim says, Dismas Vitu Vichenjanga. Entire 2 years have been positive on Raila Odinga until he talked to Uhuru Kenyatta without Mudavadi. Somebody, you'll respond to that later on. Let's take a break here on Sunday edition. Don't go too far. We are back shortly with more for you. We shall be discussing that very same issue. What is the latest on that handshake between Raila Odinga and Uhuru Kenyatta? Is anything being done behind the scenes, or